Okay, now on the record in the matter of the people of the state of Michigan versus Lyle Allen, file number 23-00156, FY, council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Jacob Riley on behalf of Mr. Allen.
Mr. Allen is present via Polycom from Ingham County Jail. Today was the date and the time that was scheduled for a hearing on a probation violation. Are we having a hearing today?
No, Your Honor, Mr. Allen would like to report.
Is that correct, Mr. Allen? You want to plead guilty to the violations?
Yes.
Please raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes.
Okay, you can put your hand down. You were previously arraigned on the allegations of a violation. It looked like you was arraigned back on November 6th. This being the 14th violation, and then you failed to appear. These violations allege that you failed to submit to random urinalysis back on August 18th, 2023, August 24th, 23, August 31st, 2023, September 7th, 2023, September 10th, 2023, and September 21st, 2023. And that you failed to attend outpatient substance abuse treatment as ordered, and that you failed to attend this 12-step program as ordered, and that you failed to complete a substance abuse assessment as ordered. And so you were advised at the time of your arraignment of your right to have a contested hearing, understanding that if you plead guilty or if you're found guilty of these violations, you can be sentenced to a term of jail time. Do you understand that?
Yes. Yes.
Your probation also can be extended, or you can have other sanctions or oversight imposed as a result of any sustained violations of your probation status. And so you wish to give up your right to a contested hearing today?
Yes. Yes.
Anybody threatening you to get you to do that? Has there been any promises made to you in exchange for you entering a guilty plea?
No.
Answer the violations that I've read just on the record. How do you plead?
Guilty.
Factual basis, counsel.
Mr. Allen, is it true that you were sentenced to a term of probation in this court in July of last year?
Yes. Yes.
And was one of the terms of that probation that you were to submit to random drug and alcohol testing as ordered?
Yes. Yes.
Is it true that you failed to submit to random urinalysis tests that were ordered on August 18th, 2023?
Yes. Yes.
August 24th, 2023?
Yes. Yes.
August 31st, 2023?
Yes. Yes.
September 7th, 2023?
Yes. Yes.
September 10th, 2023?
Yes. Yes.
Finally, September 21st, 2023?
Yes. Yes.
Were you also ordered to attend outpatient substance abuse treatment?
Yes. Yes.
Is it true that you failed to attend or complete that ordered treatment?
Yes. Yes.
Were you also ordered to attend a 12-step program?
Yes.
True that you did not attend that program as ordered?
Yes.
Were you also ordered to complete a substance abuse assessment?
Yes.
True that you failed to complete that substance abuse assessment?
Yes. Yes.
That's factual basis.
Any additional factual basis from the prosecution?
No, Your Honor, thank you.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. The recommendation from the probation department is that it says jail time highly suggested, recommends terminating the probation status, says defendant is on probation, where his probation at the 55th was also terminated for non-compliance, and he has warrants in 55th, or at least he was at the time that this was authored. Defendant has never tested, refuses to go to meetings and comply with the terms of probation, and a defendant has no intention of complying with any of the court's orders. You can make allocution.
Your Honor, after speaking with Mr. Allen, I can tell you he has represented to me that certainly he was going through a hard time during the first several months of his probation, did not complete the requirements, certainly was not attentive for the rules and requirements of probation, but given another chance, he might do better a second time around. However, the court decides to proceed, I would note for the record that he does appear to have 41 days jail credit on his file, and he was sentenced to a jail term in 55th District Court, which he's currently serving. And I believe the announced date is May 13th as of now.
I absolutely believe in second chances, but as I stated at the beginning of this hearing, This was the 14th violation, not second. And so he's indicated by his actions that he has no willingness or ability to comport with the court's orders when it comes to compliance and treatment and testing and doing what he needs to do. And even as I reviewed the file from the onset of this case, which I presided over this case from January of 2023, I've constantly had to remand him for various things just to bring him into compliance. And so I have no intentions of further babysitting Mr. Allen. I'm going to discharge and terminate his probation status. He will be sentenced to 365 days in Ingham County Jail, no earned early release, no GPS tether release. He'll serve the full amount in the Ingham County Jail. Any additional matters for the record?
I give them people.
No, Your Honor.
You're all set, sir.
Thank you, Your Honor. Thank you.
Was there fines and costs on this? I think that was all probation fees, wage fees. You can let the deputy know you're all set. Okay, on the record, in the matter of the people of the state of Michigan versus Drew Aldrich, file number 22-3313, FY, council appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Drew Aldrich.
Do we know why we can only see a keyhole of him? We contact the jail until then we can't see him.
I apologize, Your Honor. It's the waiting in this room.
Yeah, it's not anything that you had any control over. Something's going on with the Polycom and they probably need to adjust it. Nonetheless, today was the date and the time scheduled for a hearing on a probation violation. Are we having a hearing today?
We are not, Your Honor.
You want to plead guilty to the violations, Mr. Aldrich?
I do, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Your Honor.
You say that again?
Yes, Your Honor.
Okay, you can put your hand down. Okay, you were arraigned on this. This was quite some time ago because you've been in warrant status, and it states here there was a request and summons for probation violation. That was from September 27, 2023. The allegation, sir, that you violated your probation by making an untruthful report to probation on September 6th regarding enrollment in MRT program. Also that you failed to do testing on September 6th, September 15th, September 21st. Also that you failed to attend the domestic violence section on August 29th, September 19th, and September 26th, and you failed to re-enroll in MRT program after your last violation on August 14th, 2023. And so that would have been, if you had 9 prior violations plus this amounts to about 7. So that's 16 violations if sustained. You want to plead guilty to those violations, correct? Mr. Aldrich, can you hear me?
Yes, Your Honor.
You want to plead guilty to all the violations I just read?
Yes, Your Honor.
Okay, you understand your right to have a contested hearing?
Yes, Your Honor.
You understand the possible penalty if you plead guilty?
Yes, Your Honor.
As to the violations that you made an untruthful report to probation on September 6, 2023 regarding your enrollment in the moral recognition training program, how do you plead?
Guilty, Your Honor.
As to the violation that you failed to do testing as ordered on September 6th, September 15th, September 21st, 2023, how do you plead?
Your Honor.
And the violations that allege that you failed to attend domestic violence sessions back on August 29th, September 19th, September 26th, and failed to enroll in MRT program after the violation of August 14th. How are you pleading?
Guilty, Your Honor.
Factual basis, please.
Yep, thank you, Your Honor. Mr. Aldrich, did you plead guilty to a domestic violence charge in this court in 2023?
Yes, sir.
And as a result of that, were you sentenced to a 12-month term of probation?
Yes, sir.
And as part of that probation, you were ordered to participate in MRT programming, correct? And you were also ordered to participate in random testing, correct?
Yes, sir.
Okay. And so you had to take DV classes or attend DV sessions, right?
Yes, sir. Yes, sir.
Okay. So in August 29th and September 19th and September 26th of 2023, did you fail to attend the DV sessions?
Yes, sir. Yes, sir.
And did you fail to re-enroll in the MRT program per the orders from your probation officer?
Yes, sir. I was waiting for the new class to start.
Right. And so when you told him that you had enrolled, that was not completely truthful because in point of fact, the classes hadn't restarted, correct?
That is true, sir, but Pass had told me that I was already signed up for it.
Your Honor, I'm not sure that, well, I'll come right back to it. And did you fail to participate in random testing on September 6th, September 15th, and September 21st?
Sir.
Okay. And just to be clear, did you make an untruthful report to probation on September 26th? I'm sorry, on September 6th, 2023?
It was untruthful, sir, yes.
Thank you. Okay.
Any questions from the prosecution?
No, Your Honor, thank you.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be made freely, voluntarily, and intelligently. I do have a recommendation from probation as to your sentencing, but this was prepared back in October 2023. It doesn't appear to have been updated. It says, recommendation is to terminate probation. Jail is highly suggested. It says the defendant has made no progress since his last violation, August 14th, 2023. Defendant reported on September 6th that he had re-enrolled in MRT but had not done so. You can make application.
Thank you, Your Honor. I believe that the first part of the story is about miscommunication. Mr. Aldrich was in communication with his probation officer about enrolling in the MRT program. He reports that he did in fact contact the MRT program, but was advised that they were in the middle of a session and that he would have to wait till a new section or session of classes began. So when he reported to his PO that he had enrolled, that was not entirely truthful because a new session had not yet begun and he was not technically enrolled. But I don't think he meant to mislead the PO. I think he just did not communicate very well. He in early September suffered a loss. His stepfather passed. He was distracted and admits that he lost track of probation and testing and so forth. Unclear as to what caused further delay in following back up with the probation officer, but reports that in January of 2024, he got a letter from probation and misunderstood it. According to his understanding, he thought that the letter was telling him he was on probation. Obviously, that's not true. Only the judge can do that. So in the meantime, he has been working at SE Growth, which is construction and redevelopment. He also owns his own construction company and does subcontracting. His primary concern, other than, of course, being reinstated to probation and complying with the orders of the court, is that he be available for his 18-year-old daughter. She's here today in the courtroom to offer her support to him as well. Her mother is going to be going to prison soon, and he's concerned that she won't have anybody there to help her and guide her and help provide for her, and he wants to be there for her. So that is his primary motivation. If the court allows him to be reinstated to probation, to comply with the orders of the court.
Why in the world would I let someone with 16 violations be reinstated to probation? He doesn't follow court orders. Why would I do that? I can appreciate that he's had some hard times. But sorry to hear about his daughter. She's the victim in this because she didn't have the support system that she needed. But you didn't do what you were supposed to do to be a good father. And having her come to court and bringing her up in the middle of your sentencing is not going to negate the fact that you have completely disregarded all the things that the court put in place for your rehabilitation on a DV second. Which is punishable with 365 days that you're going to get, by the way, because I can't continue to babysit adults. You're adult enough to understand how to be a general contractor, to own your own business, to work for someone else, but you're not adult enough to know that you're supposed to follow the orders of the court when you put yourself in a position by your own actions to be here on violent offenses. And this is not a first offense for you. And so using or trying to follow on the crutch of some downfalls that's happened in other people's lives. I apologize that you lost your stepfather, but you're a grown man. As we age, our parents will go on and transition. We don't get to not take care of our responsibilities because we lost a loved one. We don't get to not take care of our responsibilities because we have children who may have other issues going on. That's all the more reason why you should have been taking care of your responsibilities before today, because you have been a dad at least for 18 years if you have an 18-year-old daughter sitting here. And so to come in here and think that I'm going to give you some sympathy for that, I'm not. My only sympathy is to your daughter. It's not to you because you put yourself in these positions. The order of the court is to terminate probation. He will be sentenced to 365 days Ingham County Jail. I will give him credit for time served. We don't violate probation 16 times. I mean, that's more than gracious. I think I've been too lenient, and I think that is something that needs to change. I'm not going to continue to reinstate probation's violation after violation after violation, and you're not going to cause me to believe that you forgot about your probation. You're not going to cause me to believe that you think you got a letter that told you that you were not on probation. You absconded. Yes, fines and costs in the amount of $362 that will be referred to collections. Any additional matters for today's record?
Nothing from the people.
Nothing for the defense. Thank you.
You're all set, sir.
Thank you, Your Honor.
Thank you. On the record, in the matter of the people of the state of Michigan versus Lindsay Buffington, file number is 20-03146. This is scheduled for an arraignment on a probation violation, and I have a new one to arraign you on as well. What was she scheduled for previously?
The one that you signed, she scheduled it. She wanted to be.
Oh, sounds good. I have a new probation request and summons for probation violations. It says that you violated the terms and conditions of your probation by Failing to refrain from alcohol at EverHealth, you tested on April 29th positive for alcohol, yielding a result greater than 25,000 nanograms per milliliter ETG and 7,088.53 nanograms ETS. And so you have the right to be represented by an attorney. You have the right to have a contested hearing. If you're found to be in violation of your probation status can be revoked. You can be sentenced to a term of jail time. Do you understand that?
Yes.
Yes. Okay. Your probation also could be extended if the violation is sustained, and you can have increased oversight, including scram, tether, sober link, or interlock device. Did you want to request a court-appointed counsel to represent you on this?
Yes, Your Honor.
Okay, I'll note that here on the file. We'll set it for a hearing. You need to appear in person. Your hearing is May 21st at 1:30, okay? Okay? Can you hear me? I don't know if you froze.
Yeah, it keeps breaking up. Yes, ma'am, I heard you.
Okay, sounds good. I don't know if Mr. Lee stepped out. Did Mr. Lee step out? So one of you all is gonna have to meet with her. I don't know if it's gonna be him or her. But whoever's on Kane is not gonna be the person. Hang tight, Ms. Buffington, we'll get a public defender to meet with you in just a moment, okay?
Okay, thank you.
No problem. It's in the jail.
Yeah.
Who is in the jail?
Total.
Thank you. Okay, let's see. Are you on Kane? Okay, on the record in the matter or matters of the people of the state of Michigan versus Noah Kane, file numbers 24-00-825 and 826, and then 244-349-7092. Counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Jacob Riley on behalf of Mr. Kane.
Okay, Mr. Kane, how are you?
Good.
I'm well, thank you. I have a reckless driving pre-trial as well as no insurance and then open end talks. How are we proceeding?
But our offer for Mr. Kane was if he were to provide proof of insurance, we would dismiss all counts on this file. And he has provided us with that proof of insurance, so we would be dismissing.
I think we're all on the same page. Motion to dismiss is granted. You're all set.
All right, thank you.
You're welcome. Okay, on the record in the matter of the people of the state of Michigan versus Barbara Hatcher, file number 24-00800 and 24-00801. Counsel appearance, please.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Okay, Ms. Hatcher is without counsel, is that correct?
Yes, that's correct.
Yes, that's correct. Okay, she requested court-appointed counsel. Was she denied?
I was denied. Yeah, I received a, I'm sorry, Your Honor. I apologize. I was denied. I did receive a phone call, a text message that I was denied. I'm sorry.
Okay, so you have two counts of unlicensed dog.
Yeah.
Have you spoken with her already?
No, I haven't, Your Honor. I wasn't sure if she was pro or if she just hadn't had counsel plan yet.
Okay, so you have the right to have an attorney represent you, or you can waive your right and assert your right to represent yourself. You can appeal the denial if you like to the public defender's office, or you can hire your own attorney. Or you can proceed to represent yourself. How do you want to proceed, ma'am?
Thank you, Your Honor. I would like to represent myself. I hope I have the material that you need today, but I would just go ahead and just do it myself, if that's okay.
Oh, okay. The standard offer is that if you provide compliance, meaning that you got the dog's licensed that they would dismiss. Is that the offer in this case?
It is, Your Honor. I believe, yes, if she were to provide proof of licensing for both dogs and then proof of securing the dogs, we would dismiss for compliance.
Was she charged with dog at large?
That's what I have in my notes, but now I'm doubting. So
I
we
just
check.
have, I have two dog, unlicensed dog. I don't have a dog at large.
That's what she said.
I did have a dog at large, but it said there was a warning. I don't see it on my docket for today.
Oh, that would, yep. I just misread the ticket. My apologies. Yes. So she would just need to provide licenses for both dogs and we would dismiss for compliance.
Okay, do you have proof of your license, ma'am?
I do, Your Honor. I tried to come down there last week, a week or two ago to show you all. I do have proof of the license. Yes, yes, ma'am, I do.
Are you able to email a copy of those licenses to us?
I can if you like. I can bring a copy down to the office today. I'll do whatever it takes to get this
Well,
off my.
it's kind of dark. I don't know what's gonna happen. So let me give
Okay.
you an email. Send it to Judge Simmons Courtroom at
I'm sorry.
lansingmi.gov.
I'm sorry, Judge. I wasn't ready. I was trying to get my pen. I apologize.
No problem.
Uh-huh. Okay.
Judge Simmons Courtroom
Mhm.
at lansingmi.gov.
Okay. Okay. So I could just pretty much scan it and make a copy and put that into your email, ma'am?
Yes, that's probably the easiest way for me to get it to the prosecutor while I'm in court today, if you do that today. And then
Oh.
she can make a motion to dismiss. So we'll call your case again in just a moment. I'll let you do that now, okay?
Okay, okay. Wish me luck. Okay, I'll try this. Okay, thank
Good
you.
luck.
Uh-huh.
If
Thanks.
you, ma'am, if you can't scan it, but you can take a picture and if you're able to attach a picture of the dog licenses and email that, that would work as well. If you're
can
not
do
able
that.
to scan them.
Okay, yeah, thank you. I think I got too excited because it's almost close to ending. I cannot scan. I was just trying to make a copy of it, but I will take a picture of it and I will send it to the judge right now. Do I leave or do I stay here? Is what I'm asking now. Do I stay here in the meeting?
You should stay here because if we get it, my staff will forward it to Ms. Petrovsky and then she can make her motion if she's satisfied, okay?
Thank you both so much. This has been so way better the first time. I will take care of it. I will mute myself and I will take care of this now. Thank you very much.
No problem.
Thanks.
Okay. Do we have James Hogan here? Who's his attorney?
That's one of Mr. Raleigh's. Let me see if he's.
Okay, and Mr. Lee, who are you representing? Or you need to speak with? Just you, Lee? Oh, Mr. Lee is supposed to go to the breakout room.
Thank you, Your Honor.
Thank you. You're in room 1.
Mr. Raleigh's on the phone with somebody, but he'll be in as soon as he can.
Okay, sounds good. I can do this. On the record, in the matter of the people of the state of Michigan versus Stanley Grott, file number 23-02213FY. Council appearances, please.
Good afternoon, LaDonna Logan on behalf of the people.
Good afternoon, Your Honor. Derek Wolchinski on behalf of the defendant, Stanley Grote.
Okay, thank you. And I think Mr. Grote was not present, but his presence was not needed for this purpose. This was a hearing to address the defendant's motion for an adjournment of the preliminary examination. And the defendant has a conflict. He has a trial that's supposed to go before Judge Coretti. This is a matter that this court requested and solicited the court dates, and particularly trial dates of all of the defense attorneys on this matter. I requested them to send dates to my staff for the months of May, June, and July because of the extensive nature of the evidence and testimony that would be needed to put forth the preliminary examination in this matter, and the fact that it's about 9 co-defendants right now. And so my staff did their due diligence in navigating my docket, rearranging things. I even gave up a vacation day so that I could fit this in during this week. And so for those reasons, the court is not inclined to reset everyone's examination. I understand, Mr. Groff, I'm sorry, Mr. Wazinski, that you have a conflict that's outside of your control because the court that you had another trial date on switched your trial to begin in the middle of our examination. Your matter is obviously can go at another time. It just won't go with the other matters because I'm not resetting them.
Understood.
And so,
And Judge, let
and
me-
at this point, I wouldn't even be able to give you a time frame as to when I'll be able to start yours because
I
I'm
understand.
gonna have to move forward with these other ones. And I even, by way of making the record as clear as possible, I even had a brief conference with Judge Peretti yesterday, actually, us trying to figure out how we can best navigate this. And I think his concern was that there's some expert witnesses on the civil matter that you're proceeding a trial on that won't be available into October. It's an unfortunate situation because the court dockets are what they are, but I'm not in a position to now cancel this and reset these attorneys and these witnesses that we've had lined up to go for this week. I literally blocked off 7 days consecutively and had to secure an additional courtroom because my courtroom's not big enough for all the attorneys. We were barely big enough for the first set of these co-defendants. So unfortunately, we won't be able to reset everybody, but obviously your client still has his right to have his preliminary examination. It'll be set at a time in which not just the court, but obviously the prosecution can dedicate time in their docket as well to restart this exam, which again, we all know has voluminous amount of testimony and evidence.
Judge, thank you. I do want to tell the court, and this is always difficult to say because you don't want to sound like you're pandering, but I know you and Judge Coretti worked together in this, and I appreciate everything your staff did. Unfortunately, like you said, sometimes these things are out of our control. The last thing I wanted to do was have to file a motion in either case, but it is what it is. The evidence in both cases is extremely voluminous, and I am the attorney that not just knows most of everything, but knows almost all of everything in both cases. So you have my apologies for having to come to the court. As you know, I didn't do it intentionally or try to get around something. It is what it is. And you know, I appreciate all of the efforts your court and your staff did. I talked with Miss Nash and she was, you know, fantastic in terms of getting you a copy of the motion. And I just want to let you know, because I don't think attorneys are often appreciative enough of how hard you all work, but you did great. And I appreciate that immensely.
No problem. And I will say Judge Coretti was wonderful as well. And he didn't want to give up hope. He said, let's not give up hope. I don't know what he's going to pull out of his hat because I don't have the ability to reset
Sure.
8 other co-defendants at this point. And so I would have loved, ideally, I would have been able to do this in one iteration. That would have been a cluster, but it would have been great. But if we have to do 3 iterations, it is what it is. Things happen.
Thank you, Judge. I appreciate it.
Thank you. Any additional matters for the record?
There are
None for the people.
Thank you, and good luck to you on your trial, sir.
Thanks, Judge. And thank you, Ms. Logan. I appreciate it.
Anytime. Everybody take care and be safe.
Same to you. Ms. Hatcher appears to have sent an email. Is that correct? We'll have someone check.
Yes, yes, Judge, I'm sorry. Yes, Judge, I had myself on mute.
You must be slow. Okay, we're just still waiting for it to come through. Okay, Mr.
I appreciate it. Thank you.
No problem. Mr. Raleigh, you're on which matter?
I have several, including Hogan, Jackson, Gates, and Johnson. As well as the
Okay, on the record in the matter of the people of the state of Michigan versus James Hogan, file number 24-01089, counsel appearance.
This is the prosecutor, Paige Petrosky, on behalf of the people.
Jacob Raleigh, on behalf of Mr. Hogan.
Okay, Mr. Hogan, today is the date that's scheduled for a pre-trial on a malicious destruction of personal property. Was there an offer extended on this?
There was, our offer would be for Mr. Hogan to plead guilty to an amended count 1, malicious destruction of personal property less than $200 and pay restitution. We do not currently have the restitution amount, but I have spoken with the victim and she's getting me the documentation for that.
This time, Your Honor, we would ask that this matter be set for final pre-trial and trial dates.
June 25th at 8 a.m. Final pre-trial. July 23rd for the jury trial. Okay, your final pre-trial, sir, is going to be in person at the court June 25th at 8 o'clock in the morning. The complaining witness is required to appear in person as well. Jury trial, if we proceed, will be scheduled for July 23rd, 8 a.m. in person at the court, okay?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing from the people.
I think I'm just answer.
You're all set, sir. We'll get you your notice to appear. So, okay, Ms. Hatcher, I just want to make sure you sent it to the right email. You sent it to Judge Simmons Courtroom at
Oh, no, ma'am.
lansingmi.gov.
Okay, I apologize, Judge. Can you repeat that? Because it wouldn't let me send it to, maybe I wrote it wrong. Can we just say it real slowly for me, please? One more time, please?
No, no problem. Judge Simmons
That's what I thought.
Courtroom
Courtroom, okay.
at lansingmi.gov.
Let me try that again, Judge. I did something wrong. I didn't put courtroom. I put something else. Okay, let me try it again. I
Okay.
apologize. Thank you.
No problem. Okay. On the record in the matter of the people of the state of Michigan versus Felicia Jackson, file number 23-02951, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Jacob Rowley on behalf of Ms. Jackson.
Okay, Ms. Jackson, today's the date that was scheduled for a pretrial on abandoning cruelty to the 3 animals. How are we proceeding?
This time, Your Honor, that you would request final pre-trial and trial sentence.
Was there an offer?
There was, the offer would be for Ms. Jackson to plead guilty to an amended count 1 of cruelty abandonment to 1 animal and pay restitution in the amount of $3,637.
1 animal and restitution of how much?
$3,637.
Okay, I'm not doing a final pretrial, set up for trial. July 23rd at 8 a.m. Offer will expire the Friday before trial, okay?
Thank you.
Thank you.
We'll get you a copy of your notice to appear. Kevin Kemp here.
He's not.
On the record in the matter of the people of the state of Michigan versus Shawnee Norton. Wait, is that your client? Okay, I'll do Yates. People of the state of Michigan versus Gabriel Yates, file number 18-00758, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Jacob Rowley on behalf of Ms. Yates.
Ms. Yates, today's the date that's scheduled for a larceny. Was there an offer in this?
There was, Your Honor, the offer would be for Ms. Yates to plead guilty as charged with hideout.
This time we will be requesting final pre-trial and trial date.
July 2nd at 8 a.m. for the final pretrial. And July 23rd at 8 a.m. Okay, final pretrial. It's going to be July 2nd, 8 a.m. in person at the court. Jury trial, if we proceed, is scheduled for July 23rd at 8 a.m. in person at the court, okay? Do you have any questions at this time? We'll get you a copy of your notice to appear. Any additional matters for the record?
Nothing for the people.
No, Your Honor.
And you just have Tuttle after that, correct?
Cameron Johnson as well.
I think they removed Tuttle. I don't know why. Got it. Let's see. Yeah, who else?
Cameron Johnson.
On the record, in the matters of the people of the state of Michigan versus Cameron Johnson, file number 24-00912 and 24-01040. Appearance for the record.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Jacob Rowley on behalf of Mr. Johnson.
Okay, Mr. Johnson, I have one file, domestic violence. Another file, malicious destruction of property. Less than 200. How are we proceeding, counsel?
Honor, we will be requesting final pre-trial charges on these cases.
Is there an offer?
There is. The offer in this case is a global resolution between the two files. If Mr. Johnson were to plead guilty to domestic violence with 7694A in 24-01040, we would dismiss count 1 and file 24-00912. Oh, and pay restitution totaling $277.
A restitution of $277,
$77.
and that would be on file 24-01040.
Yes, that's correct.
Okay. Just so I'm clear, because there's actually domestic violence in that file, so if he plead to the DV and file number ending in 912,
No, plead to the DV in the file ending in 1040. And we would dismiss
Okay.
malicious destruction in that file. But be asking for restitution in that file, and then we would dismiss the file ending in 912.
good, okay. And you want a final pretrial and jury trial?
Yes, Your Honor.
July 2nd, the final pretrial. July 23rd.
Okay, so your final pretrial is gonna be in person at the court July 2nd, and then if we proceed to trial, it's scheduled now for July 23rd in person at the court, okay? Your offer expires at the time of your final pretrial. Do you have any questions for the court? Any additional matters for the record, counsel?
Nothing for the people.
No, Your Honor.
We'll get you your notice to appear, okay? You can have a seat.
Whatever she's been helping it, I just trying to told her to try it.
If needed to, I can, once we get
Oh,
through the case,
okay,
I can
get
hop
you
on the
on-
record and she can show me.
Sounds good. Okay, let's see, who's representing Ms. Norton?
John Lee.
On the record, in the matter of the people of the state of Michigan versus Shawnee Lynn Norton, file number 24-03139, counsel appearance.
Prosecutor Paige Petrowski on behalf of the people.
Assistant Public Defender John Lee on behalf of Shawnee Norton.
Okay, Ms. Norton is present today for one count at Darg at large. How are we proceeding?
Ms. Norton provided Mr. Lee and I with proof of securing the dogs. We will be dismissing for compliance.
Motion to dismiss is granted. You're all set, Ms. Norton. Aria Parker present?
Yes, you do.
Okay. On the record, in the matter of the people of the state of Michigan versus Aria Parker, file number 24-00836, counsel appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Assistant Public Defender John Lee on behalf of Aria Parker.
Okay, I have one count here of domestic violence. Was there an offer?
There was your honor, our offer would be for Ms. Parker to plead guilty to the charge of domestic violence with 7694A.
Final pretrial and jury trial?
Yes, please.
1 second. The final pretrial, July 23rd.
Okay, we'll set your matter for final pretrial July 2nd in person at the court. It's currently scheduled for jury trial July 23rd. If you're going to proceed as you might have heard there's multiple set for July 23rd. So we go with the oldest case number first, and that would not be yours at this time, okay? So final pretrial, and we'll see if we'll proceed to trial. Any additional matters for today's record?
Nothing from.
Nothing for the defense.
We'll get you your notice to appear in just a moment, okay?
Thank you, Your Honor.
You're welcome. Okay, I think I did that one. If you want to log in, and then you can get her proofs for us.
Yeah.
Ms. Hatcher, we're just gonna get the prosecutor on Zoom to look at your, you can show her on the screen when she gets on Zoom, okay?
Yes, Judge, I've tried to send it 3 times. I'm not sure what, I was just trying to send it to your assistant just now. It's like, I
No,
don't know why.
we did receive
Oh.
it. We just we couldn't open it.
Oh, why not? What happened? Huh?
I don't know, we might not be able to open the type of document it is. So sometimes it has to be like a PDF or a JPEG. It's
Oh.
tricky.
I
But
took a picture of it. Okay, I'm
you
trying
did a good
here.
effort. But she's logging in now, and then I'm gonna put you both in a breakout room.
Okay,
Let's see.
thank you, Judge.
No problem. No problem.
She's back.
Okay, back on the record, Ms. Hatcher. You're still there. If you're muted, I can't hear you.
She left. It was not intentional.
Ms. Hatcher, are you there? I see her. She's just muted. Okay. Are you moving to dismiss?
Yes, we are. Or I am.
Motion to dismiss is granted.
Okay.
I don't know what happened.
Can you hear us?
No, I can hear you, yes, but I don't know what happened. I don't know why it will not let me undo it. Oh, there it is. Can you hear me?
I can hear you.
Hello? Okay,
Okay,
look a hot
the
mess.
people have dismissed, so you're all set.
Okay, thank you. I apologize. I don't know what happened. Everything froze on me, you guys. I know about Zoom. I used to train at Mesa, but I don't know
No,
what's going on. So
no. Zoom does that sometimes.
yeah, you got me good. I know I look like an idiot over here, but I was trying.
It happens to us. No worries. Have a good
Thank
one.
you. And thank you, ladies, both, all you all. Thank you so much. I do appreciate your time today, okay? I mean that. Thank you. All
No
right,
problem.
bye-bye.
Not yet.
They're going to, the guy that just like I said.
No, David just runs, David does one-on-ones with people, but that's the single.
We're not finished with him yet. Okay, let's see. Okay, on the record, in the matter of the people of the state of Michigan versus Corey Grock, file number 23-03803, counsel appearance.
Assistant Prosecutor Paige Petrosky on behalf of the people.
Assistant Public Defender John Lee on behalf of Corey Brown.
Okay. This is a retail fraud third degree. How are we proceeding on this?
It's my understanding that Ms. Grout will be accepting our offer and pleading guilty to attempted retail fraud third degree and paying restitution in the amount of $79.95 to the victim in this case, which is a story that I can't. And I'm in the process of filling out that application.
Young's Beauty Supply?
Yes.
And your client wants to accept that offer?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? In order to plead guilty to the amended count of attempted retail fraud in the third degree, you would have to understand your rights and then give them up. First, you have the right to the presumption of innocence, so you're innocent until proven guilty. Do you understand that? You have the right to require the prosecution prove your guilt at a jury trial. You have the right to remain silent at that trial and not have silence be used against you. You can see, hear, or question any of the witnesses called to testify against you by right. And you have the right to waive your silence and testify on your own behalf. You can subpoena witnesses to testify for you at trial, and you can present evidence at trial that you believe show a defense to the charges being brought against you. But you ultimately have the right to require the prosecution meet their burden, which is to prove each element of the charge being brought against you beyond a reasonable doubt. Do you understand that?
Yes, sir.
You willing to give up all of those rights? Anybody threatening you to do that?
No.
Has there been any promises made that entice you to want to give up your rights? Are you currently on probation or on parole?
I'm on probation.
Okay, before which court?
Clinton.
Okay, and you understand that a guilty plea could have an impact on your probation status? When were you put on probation in Clinton County?
February 26th when I got sentenced.
Okay, so recently?
Yeah.
Oh, so this would have been prior to that. So it's not likely that this will have any impact on your probation status, okay?
Okay.
But
I was like,
if you were on probation prior to, when this alleged incident occurred, this could affect your probation status. you
Oh, no, I
understand?
wasn't.
Okay,
No, and she knows about this incident.
okay, very good. And you also understand that a guilty plea could result in a conviction that may have impact on where you can travel or immigration status that you might seek in the future. You understand that?
Yes.
So you maybe can't travel to certain places with a retail fraud conviction. You understand that?
I didn't know that, but yeah, I do. I understand.
Okay, then also, you would have to report this. You may have to report this conviction to your employer or put it on a future job application. You understand that?
Yes.
Okay. And you're willing to still give your rights, understanding those things?
Yes, Your Honor.
As to the amended count 1 of retail fraud third degree, how do you plead?
Guilty.
Factual basis.
Thank you, Your Honor. Ms. Rowe, on or about October 14, 2023, at 1315 West Holmes Road, otherwise known as Young's Beach.
Yeah.
Okay. And that is in the city of Lansing, County of Hingham, state of Michigan, correct?
Yes.
And did you at that time leave the store with an armful of beauty products, including comb, scrunchy wigs, phase wigs, and other assorted cosmetics?
Yes.
And you left without paying for them?
Yes.
Okay. No further questions.
Any questions from the prosecution?
No, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea and find your plea to be made freely, voluntarily, and intelligently. Restitution will be ordered in this amount of $79.95 payable to the Youngs Beauty on 1315 West Holmes. She's currently on probation. Until when?
I got sentenced to 2 years of probation on the 26th of February in Clinton County with Monica Bailey as my probation officer. So I know it starts the 26th. I don't know when it ends, because I think that I can get off early as long as I take my class, but it's not at least for a year. I'm gonna have a year of probation at least. I know that. If not 2.
I'm gonna credit you time served on this matter. You'll pay the fine. $25, which includes crime victim rights fee and state minimum costs. Plus the $79.95.
And I pay that to this court, sorry.
That is correct.
Okay. Can I have that put out, because I don't get out until July 22nd.
Okay,
That way it doesn't start until I can actually make payments on it. Is that okay?
that's completely fine. You're gonna get out in July, so when are you intending to make your first payment?
Can we do August? And that way I know it's like, at least get a couple of weeks to get out and know that I gotta pay it.
You get out July 25th, you said?
22nd,
22nd.
unless I get into treatment sooner and then I would be in treatment, which I will let the courts know that I'm in treatment and that's where I'm at, but, yeah. That's what I'm waiting for, is to go to treatment. But I had to take-
Sounds good. I'll put here that you'll make your first payment August 23rd,
Okay.
2024. I put that you'll pay $20. Obviously, you can call the court and make adjustments, or you can come up if once you're released and your circumstances change, so we can adjust that. Or you can pay it in full if you hit the
That-
lottery
that-
between now and then, okay?
Okay, thank you, Your Honor.
No problem. Any additional matters for the record, counsel?
Nothing from the people.
Nothing for the complaints.
You're all set, ma'am.
Thank you. Have a good day.
Same to you. Okay, on the record, in the matter of the people of the state of Michigan versus Alexander Marion, I have file numbers 24-01046 and 01064. Council appearance.
Assistant Prosecutor Paige Petrowski on behalf of the people.
Assistant Public Defender Donnelly on behalf of Alexander Marion.
Okay, Mr. Marion, there was a extensive endeavor to get you before the court today. I don't know why they hadn't put you on. You were supposed to be here this morning at 10 o'clock. But Ingham County didn't get you on. So we do have you here now. You have 2 retail frauds. One is a retail fraud. Second, was there an offer on this?
There was, Your Honor, both files are charged as retail fraud seconds.
Yes, they are.
And so our offer would be for Mr. Marion to plead guilty as charged in either file, dealer's choice, and we would dismiss the other file, and he would be paying restitution for both files, which for a total amount of $469.98.
Okay, Mr. Lee, how does your client want to proceed?
Your Honor, I have not yet had a chance to discuss this offer with Mr. Marion.
Okay, we go off the record. You can go talk to him. Put him in a private meeting. First to meet